city civil court in the Chennai and district municipal courts in the other parts of the Chennai. Likewise, there is an appeal. From the appeal, second appeal lies to the High Court. From the second appeal, ultimately the persons having the money power would resort his dispute till the Supreme Court. In the course of these disputes, it may consume around several years. When the several years goes, the party turns back and sees the amount which was under dispute has very meager, or the dispute which was for past 10 years or 15 years, it could have mutually been settled at that time itself to have a peaceful relationship. In these circumstances, the another major object of the act is when the party settles that dispute, there is no question of appeal, there is no burdens of the court further. Every party is generally interested to have his own way of procedures in conducting the case. They select their own persons to become as an arbitrator, and they believe that, okay, so and so A, if he is selected as an arbitrator who is known to both the parties, disputing parties, they believe that those party who is the mutually known to both the parties could settle the dispute amicably, and he is a person of impartial in nature. So the entire act aims to give a freedom to the parties, that is the freedom to determine their own arbitrators, number of arbitrators, procedures, other aspects, which is the another object of the act. The parties are free to determine their own place, the language in which the entire proceedings to be conducted. Several parties are from the remote villages, may not be well conversant with the English language, or they wish that the proceedings to be conducted in their own languages, as both the parties are well conversant with their own language. In such circumstances, the Arbitration and Conciliation Act encourages such types of disputes and settlements among the parties, which is the major object. When the proceedings are conducted in the arbitration before the arbitral tribunal, the party of one disputing party may still feel that why to conduct the arbitration proceedings, why to come before the arbitrators. Still, we can personally settle ourselves between the parties. Why to make a neutral arbitrator? In such circumstances, the act still encourages the settlement between the parties, and those settlements are made a part of the award, and those awards ultimately are enforceable as a decree, which can still be enforced against the other persons who does not obey the settlement terms. And lastly, the major object was to enforce the foreign decrees within the terms of India. Parties of the two different nations can come for a settlement, and if the said parties are still interested to accept the rules of the Indian arbitrations as their enforcement machinery, they can well accept the Indian arbitration, and those decrees, those settlement terms can be enforced in India. Further, not only under this aspect, when the act gives the authority to enforce the decree, the persons of the other nations are well accepts the Indian arbitration as the rules of arbitrations. With these objectives, will give an introductions about the and other aspects. These can be reduced by way of mutual settlement between the parties. Therefore, one of the major advantages of the Arbitration and Conciliation Act encourages mutual settlement of the parties. Fair and efficient procedures. Thirdly, the cost. The parties herein are free to determine their own cost with the arbitrators. Once the parties are accepting to the said arbitrator and they accept, okay, this shall be the cost of the entire proceedings or this shall be the fees for every hearing, the arbitration proceedings is conducted and cost is well within the knowledge of the parties. With this background, I would say that every parties are must come forward for the settlement, thereby have a peaceful settlement among the arbitration. With this, I hereby call upon Mr. Dr. Paul Das to make presentations about the arbitration agreement.
We'll have a coffee break now. What is given in the schedule, and please help yourself. Coffee is served outside. Go and have and make a network. You're meeting new people. You're seeing new faces. Make use of it, and please be back by 11:30. You have enough time now. We are closing it early, 5 minutes early. So, thank you.
To invoke it. It need not be in a regular agreement form. It may be an exchange of letters, telex, telegrams, or other means of telecommunication which provide a record of the agreement, or an exchange of statements of claim and defense in which the existence of the agreement is alleged by one party and not denied by the other. So the offer must be there and the acceptance must be there. Both things are required for a contract. The agreement must be entered two persons or two parties who are legally entitled to contract. A person of below age of 18 years cannot enter into a contract. So that first the main condition is that the agreement must be a legal agreement. It should have been entered by the persons who are legally entitled to contract any subject. The another condition is the reference in a contract to a document containing an arbitration clause constitutes an arbitration agreement if the contract is in writing and the reference is such as to make arbitration clause part of the contract. According to the definition of section 1B, arbitration agreement means an agreement referred to in section 7 of arbitration agreement, providing that each party shall nominate one arbitrator and the other two arbitrators then appoint an umpire before proceeding with the reference. So these are the enabling provisions to have a panel of the arbitrators. For example, in certain companies, for example, National Stock Exchange or Multi-Commodity Exchange, they are having a set of regulations and bylaws to conduct the arbitration proceedings. Trading member will be there and a claim will be made by the client of the trading member. Then they will have a set of arbitrators. The matters will be referred to the panel of arbitrators if the claim is above 25 lakhs. Suppose if the claim is below 25 lakhs, a sole arbitrator or single arbitrator will be nominated. But all these things, regulations are governed by the concerned regulations or bylaws of the companies concerned. So if you want to have that arbitration act to be enforced, all these conditions has to be fulfilled, then only the parties are entitled to have the benefit of the Arbitration. One minute. What is sir? Conchal, thank you. Okay, thank you, sir. Then section 8 deals with the power to refer parties to arbitration where there is an arbitration agreement. Judicial authority before which an action is brought in a matter which is subject of an arbitration agreement shall, if a party so applies, not later than when submitting his first statement on the substance of the dispute, refer the parties to arbitration. The application referred to in subsection 1 shall not be entertained unless it is accompanied by an original arbitration agreement or a duly certified copy thereof. So unless, suppose if you want to invoke the provisions of section 9 through court of law or section 34 through the court of law, either the district court or in the high court, you must have a valid written agreement. Unless you show the agreement before the court of law, they will not entertain the arbitration petition, either section 9 or section 34 of the Arbitration Act. Then comes under the capacity of a party. Section 34(2)(a) 1 deals with the incapacity of the party who is entering into the agreement. An award can be set aside if a party to agreement was under some incapacity. An agreement with a party who is under some incapacity, like being a person of unsound mind or being a minor, is void. Such a person is neither bound by the agreement nor by the award. He can therefore apply for setting aside the award on the ground of his incapacity. Questions of capacity also arise in connection with companies and corporations and other institutions. An institution with a limited contractual capacity cannot act beyond that capacity. A limited company cannot act beyond that. They cannot go for unlimited things. It can either the agreement rescinded or the award set aside. So the capacity of the parties is the main criteria to enter in an agreement. Then section 34(2)(a) deals with the award is liable to be set aside if the arbitration agreement is not valid under the law to which the parties have subjected to. Suppose parties are entering into an agreement which is unlawful activities, then you cannot enforce. Naturally, everybody knows that every agreement must be for a lawful purpose. For example, if two thieves are agreed to loot something and share something, in there with a dispute, we will refer the matter to the arbitrator. Then such agreement cannot be entertained and there cannot be an award at all. Now, I am telling you the lighter way only, just to make it understand to the others. If there is no such agreement, the power of the proper law of contract would be the law for the time being in force. It follows the validity of an agreement would have to be tested either according to the party's choice of the applicable law of contract or according to the law for time being in force. The requirement is further reinforced by the provisions of section 28(1)(a), which says that in a domestic arbitration, the tribunal shall decide the dispute in accordance with the substantive law for the time being in force in India. Thus, the validity of the arbitration agreement would have to be tested in accordance with the law of contract for the time being in force. So, the arbitrator is entitled to decide whether the agreement, the clause containing the arbitrator is according to the law of the land. Suppose if the conditions or the agreement is not according to the law of the country, then the arbitrator is not entitled to deal with it. He can simply reject that claim of the parties concerned. Suppose if the contract is not concluded, where no contract could be concluded, it was held that the arbitration clause contained in it is also perished. An award under such circumstances was a nullity. It is the domain of the arbitrator to consider whether there was any contract between the parties was concluded or not. If there is the contract was not concluded, then arbitrator is not entitled to deal with it. The arbitrator's failure to consider this question vitiated the award. The matter was remitted to him for the consideration of that question and for submission of the award in accordance with the law. So this is a case law in which this provision was not examined by the arbitrator concerned. So again the matter was remitted to the arbitrator. Then inadequacy of stamp on agreement. Every agreement must be in writing and the agreement must be duly stamped. As far as Tamil Nadu is concerned, every agreement is to be written in a 20 rupees stamp paper. But this stamp paper, value of stamp paper differs from state to state. In Karnataka, you got hundreds of rupees there. As far as Tamil Nadu is concerned, 20 rupees only. So if the agreement is in a 20 rupees stamp paper, then it is valid. I am having one agreement on my hand. Just either in a green sheet, you can just affix a 20 rupees stamp, or you got 20 rupees stamp papers are there. So unless this stamp paper is affixed, then only the agreement will be a valid agreement. You can contract anything or you can arbitrate anything, but if you want to enforce it through a court of law, then the court will look into the matter whether that agreement is in a stamp paper, whether the award is in a stamp paper. All these things will be looked into by the court concerned which is going to execute the award. So the agreement must be a stamped paper. Then the existence of arbitration agreement and valid of award. An application challenging the existence of arbitration agreement or validity of the award, which used to be made under section 33, the previous act, which is now lie under this section subsection irrespective of the ground of challenge, except in case where the existence of the award was challenged. Where the agreement is valid, the court need not go into the validity of the arbitration clause. An application was filed for challenging the validity of an arbitration agreement and for declaration that the award was null and void. But without prayer for setting aside, the application was held to be not maintainable. It was happened to be made even before the award was filed in the court under the previous act 1940. And you see, you will have so many agreements in our day-to-day life. I am having one agreement in my hand, loan cum hypothecation agreement. There are a lot of provisions. Suppose if one company wants to lend money to purchase some vehicle, they will put a lot of conditions and other things will be there. And as far as one agreement is concerned, there are 24 conditions. Among one, condition number 15 is the arbitration clause. I will read the provisions for information. All disputes, differences, and or claims arising out of these presents or as to the construction, meaning or effect here or as to the rights of and liabilities of the parties here under shall be settled by arbitration to be held in Chennai. You can fix the place of arbitration, but provided this fixing the place should not contravene the jurisdiction of the court concerned. Suppose you are in Chennai and one party is at Bombay. The parties can choose the place of arbitration either in Chennai or at Bombay, and they can put a condition that this arbitration award can be executed either in Chennai or in Bombay. You can't put a condition that the award can be executed at Calcutta, because Calcutta court will not have any jurisdiction to entertain the award. So all these things has to be looked into at the time of entering into the contract. Chennai, in accordance with the provisions of the Arbitration Conciliation Act 1990, or any statutory amendments thereof, or any statute enacted for replacement thereof, and shall be referred to the sole arbitrator of a person to be nominated, appointed by the company. So here, the authority has given to the claimant, that is the company who is lending the money. Practically, legally this is not acceptable, but when a person wants a loan of rupees 3 lakhs, 4 lakhs or even crore, then he has to depend upon the other party. He has to accept all the conditions put forth by the other party. So simply the party agrees to this type of conditions, though it is not legally entitled to do it, he accepts that conditions. There is no other alternative. In the event of death, refusal, neglect, inability or incapacity of the person so appointed to act as an arbiter, that is, may appoint, that is, again, the company may appoint or a new arbitrator. The award, including the interim awards of the arbitrator, shall be final and binding on all parties concerned. This clause is quite unlawful. That's what I am telling. You cannot you cannot restrict the jurisdiction of the court concerned, because when an award is passed, then it can be challenged by under section 34 of the act at the either at the district court or at the high court. So this is a restriction on the right of a party to seek legal remedy through court of law. So this line is very unreasonable. The arbitrator may lay down from time to time the procedure to be followed by him in conducting arbitration proceedings, and shall conduct arbitration proceedings in such a manner as he considers appropriate. Any proceedings to be initiated in any court of law in pursuance of this arbitration shall be instituted and held in the court of Chennai only. This is legally accepted because I'm a money lender. I have to safeguard myself. So suppose if I am lending a money to a person who is residing at Calcutta and I am residing at Madras, then I can say that all the matters has to be dealt with only by court at Madras only. Because Madras court is having the jurisdiction to do it. Or there may be a clause for having the resort of court jurisdiction at Calcutta. So earlier I said that you cannot resort the jurisdiction of a Bombay court or any other court apart from Madras and Calcutta. Then the question of next, termination of agreement. The arbitration clause in a contract would survive even where the contract is terminated prematurely by one of the parties or comes to an end on its maturity. This result followed in a case in which the sale outlet of a retailer was terminated by the other party, and the latter was able to get the retailer's suit stayed because it was for the arbitrator to decide the termination was justified in the circumstances which were that a sample had been taken from retailer's outlet and it was under analysis, and the police case against him was under investigation. So even if the agreement is terminated prematurely, the person who is affected by the termination can resort to the arbitration proceedings. That's what it means. Then the question of supplementary agreement. An appointment of an arbitrator in connection with a dispute under supplementary agreement was held to be valid, though the arbitration clause was in the main agreement only. Suppose already there is an arbitration agreement which contains arbitration proceedings and provisions. Then the parties are entering into another supplementary contract. That supplementary contract does not have the provision of arbitration clause, but still the decision says that you can implement the earlier agreement, and the supplement agreement is also liable to be have the agreement arbitration provisions. The court said that the supplementary agreement was a part of the main agreement and was therefore bound by the provisions in the main agreement. Then another question is substitution of the agreement. Parties gave a go-by to the original agreement and agreed upon a new procedure for appointment of an arbitrator. The defaulting party failed to appoint even according to the new agreement. It was held that the other party was entitled to approach the Chief Justice for appointment of an arbitrator. Suppose even if the one party is given a go-by to the earlier agreement and have a subsequent agreement, even that subsequent agreement is not implemented, then the affected party is entitled to go for the redressal through court. Then the main issue, the agreement permitting civil suit. A clause in a supplementary agreement provided that a dispute, if any, was to be settled by the executive engineer, and on his failure to do so, it would go before the chief engineer. And if the latter's decision was not acceptable or was not given within the stipulated time, the contractor would be free to approach the civil court. I put one question to the audience, whether this clause is permissible or not. I will read again. A clause in a supplementary agreement provided that a dispute, if any, was to be settled by the executive engineer, and on his failure to do so, it would go before the chief engineer, and if the latest decision was not acceptable or was not given within the stipulated time, the contractor would be free to approach the civil court. Is it correct or is it not correct? Anybody? Sir? No, sir. No, sir. Because there is no finality at all. Even if a chief engineer is appointed as an arbitrator, then the decision is not final. Suppose if he is not giving any decision within a stipulated period, it's not a final. So the court says it was held that the provision made it clear that the final adjudicating authority was the civil court and not the chief engineer. So there was no manifestation of any intention for arbitration. So there must be a definite, you can't restrict the powers of a person. That's what. Then closing of contract, next. Where the railway authority decided to close a contract due to land problem without any liability on either side, because no work had been done yet, and asked the contractor to give his consent for the same, it was held on the contractor's refusal to consent that the matters arising out of the refusal and its consequences were to be decided by the arbitrator. Even after the contract is not enforced by the railway authorities, still the affected party can go for the arbitrator on the ground that the conditions was not fulfilled by the railway authorities. The circumstances deserved the appointment of an arbitrator. The contractor's claim for loss of profit due to the closure of the contract and due to the unavailability of any other work were not within the items mentioned in the accepted matters in the contract. Then another provision is purchases through successive orders. Agreement between the parties carried on arbitration clause, and the first purchase order issued under the contract also mentioned it and also spoke of jurisdiction. But the second purchase order carried no such mention. The court said that the second purchase was also issued under and in continuation of the main tender document, and therefore even if it was silent about the settlement of disputes through arbitration, the provision in the main agreement was similarly. Earlier I said that supplementary contract can also be entered into as executed as the original contract. Then deletion of arbitration clause. Previously